Now I request Sir to take the session forward and enlighten us all. You can all ask your questions in the chat box.
A warm welcome to all of you. Good morning, good evening, good afternoon, depending upon which jurisdiction you are joining from. We have a sunny afternoon here in India. So, good afternoon to all who are joining from India. Today's topic is quite an interesting topic where we are, and a little contradictory to an extent, because we are talking about enforcement of a mediated settlement agreement. And if you have read my post on LinkedIn, I had very specifically mentioned that this is the controversy which we are going to talk today, which I am going to talk with you, and maybe I would also invite your thoughts on this. And the contradiction is this, that generally speaking, when we say mediation, we all know that mediation is sort of a win-win situation process. Yeah. So when there is a win-win situation, meaning thereby that both the parties have come to a common ground, of understanding, of to resolve a particular dispute. So if that is the case, then why enforcement? Because generally enforcement is required when one party does not perform what has been agreed upon. Correct? That's the general understanding of when we talk of something to be enforced, meaning thereby a direction is to be given to a party who's not performing as per the agreed terms of contract or what has been agreed upon. So at one hand, we are saying that a common understanding has been arrived at between the parties, and at the same time, we are saying that a party is not performing as per that understanding. So this is the contradiction. So what does mediation do then, or what mediation has done so far as that settlement agreement is concerned? So we are going to talk about this, but before we go a little deep into what I just discussed, let us understand why we are talking of this enforcement, what is a mediated settlement agreement, and then we move on to understand the intricacies to that. Now, the reason we are talking today about mediated settlement agreement comes out of a very, very important international convention, which we all commonly know that the Singapore Convention, which was signed in the year 2019 and came to effect in 2020. And now this particular piece of legislation definitely is a welcome step so far as the international settlement agreements are concerned, because ultimately, if you see, even if a settlement agreement, whether it happens in mediation or otherwise, it's generally a understanding or a contract at the most between the parties, because in that particular agreement, the parties would have agreed upon what to do, what not to do, and so on and so forth. There are different terms, with an aim to finally resolving their dispute. Yeah. And therefore, the need was felt to give this particular process of the settlement agreement which happens or which are concluded during mediation an international authentication. And therefore, after the detailed thought process, this particular convention came into being in the year 2019. So let us first try to go through some very important aspect of this convention to understand what we are talking today of enforcement of mediated settlement agreement. This is for the benefit of those who may not have read about the convention and those who have who may have read, it will be helpful to have better understanding. All right. So, first important article of this convention is Article 2, which defines certain very important terms like what is a settlement agreement. Okay, I'm not going in the other provisions because I'm just going through what is relevant for our today's discussion. So Article 2, Subarticle 1, Subarticle 2, I'm sorry. So Article 2, Part 2 defines a settlement agreement. So it says that a settlement agreement is in writing if it's contended in recorded in any form. A very simple, uh, you know, I won't call this a definition, but a simple understanding of what is a settlement agreement. The requirement that a settlement agreement be in writing is met by an electronic communication if the information contained is accessible so as to be usable for subsequent reference. So basically what it says that a settlement agreement has to be in writing, and then how that writing is to be derived into, we'll go into that. There is a particular article into that. But this in nutshell says that settlement agreement has to be in writing. All right. Then part 3 of Article 2 defines what mediation is. So it says mediation means a process irrespective of expression used or the basis upon which the process is carried out, whereby the parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or person, which is who's known as the mediator, lacking the authority to impose a solution upon the parties to the dispute. Now, these are some very, the main features of what a mediation is put into a consolidated form. So if we just break it, so mediation, what is mediation? It's a process. It's an alternate dispute resolution process whereby the parties attempts. Now, try to understand this word attempts. It has a very important significance because what what you may have learned, and which is you may also know, that mediation is not binding. A party to a mediation may, if he or she feels like, can walk out. It's not binding, and therefore the word attempt, unlike in arbitration, which is binding, which is final and binding, because we say that arbitration award is final and binding between the parties, but mediation is not, and therefore this word attempt. So the parties are trying their best. That's why it's called an attempt to reach an amicable settlement of their dispute. So settlement of their dispute. This is also a part of important part. Settlement of what? Of their dispute, which is referred for mediation. How? This is where it says with the assistance of a third person who's known as a mediator, and this person lacks the authority to impose a solution. So a mediator is not supposed to give a solution to the parties. He is not a judge. He or she is not a judge, unlike an arbitrator. The mediator is not sitting or, is part of process to judge or give a solution or decide basically a dispute. No. A mediator has to simply facilitate the parties in their attempt, as we just read, to resolve their dispute amicably. That is the role of a mediator. Correct? So this is what is mentioned in this particular definition, Article 4, Part 3. And then we move on to another important article, which is Article 4, and which is about requirements for reliance on settlement agreements. Correct? So it's quite a detailed, article, but I'll try to help you out understand it in a simple way. So what it says, the first part 1 of Article 4 says that a party relying on settlement agreement under this convention shall supply to the competent authority of the party to the convention where relief is sought. What? Number one, the settlement agreement signed by the parties. And number two, evidence that the settlement agreement resulted from mediation. So these are two important requirements of enforcing a settlement agreement. So what this particular article says that when a party is approaching a competent authority, here means normally the court of a respective state or a country or a place, right? Because why we are saying state or country, basically because this is an international convention. So naturally, and obviously, there will be two parties from two different countries, and therefore it it is called an international mediation, and that is why it says when one party approaches a competent authority of another party to this convention, means two different countries. Yeah. So what the party has to submit along with this application, one is the settlement agreement, of course, the original in writing, which is in writing, and secondly, the evidence to prove that this settlement agreement resulted from mediation. Now, what are those evidences? That is also mentioned in this article. If we go further down in this part B, subclause B of this part 1, so it says that what are the different form of evidence? One, this agreement has the mediator's signature. That can be, of course, that is uh, the most important evidence, the best evidence to prove that this agreement resulted from mediation. All right. Second, the document signed by the mediator indicating that the mediation was carried out. So it may happen that the agreement may not be signed by the mediator, but the mediator may have supplied a letter or something to support the fact that this kind of an agreement or the mediation was carried out between the parties, which resulted into this settlement agreement. So that can also be a kind of evidence to prove that this settlement agreement, resulted from mediation. Another evidence can be an attestation by the institution that administered mediation. Very simple. If there are institutional mediation being carried out, then of course the mediation, if it is attested by that particular institution, which prove that this agreement or settlement agreement was signed through in mediation. And this, then the fourth one is a general, provision which says that in the absence of any of the above, any other evidence which is acceptable to the competent authority. Now, so this discretion is again left to the particular competent authority, and the reason being, you see, every country and the courts have different rules so far as the evidence is concerned, and therefore this general provision is also inserted that in the absence of any of the above three evidence, it is left to the particular court of that particular country where the enforcement is sought for to agree or to accept any other form of evidence to prove that the settlement agreement resulted from mediation. Okay, this is one part. The second part, it says that the requirement that a settlement agreement shall be signed by the parties, or where applicable, the mediator, is met in relation to an electronic communication. So it may happen that this communication or this agreement was actually exchanged on email, which is also valid nowadays. Yeah, it is acceptable in court of law as well, email communication to a larger extent. So this particular part 2 talks about that kind of a exchange of email, and it says that it will be suffice, it will meet this requirement of the settlement agreement to be in writing if a method is used to identify the parties or the mediator and to indicate the parties or the mediator's intention in respect of information contained in the electronic communication. So what it's saying is two parts. One is that particular email has come from the emails have been exchanged by the parties, or through their email communication, the email addresses are of the parties who are involved in the dispute, or it also has the email of the mediator, And so this is one part, one requirement. Second, it also say that this particular email exchanges should also have the content which will lead to the proof that this kind of an settlement agreement has been involved. Okay, this is what this is talk about. Then, as I said, it has quite a detail of this, but I'm not going into further part because that is not relevant as of now. Now I come to the most relevant article, which is for today's discussion is Article 5. And the title of that article is Grounds for Refusing to Grant Relief. Now, mind you, we are talking, you see, today's topic is enforcement. But if you read the convention, there is no article on enforcement. What the article says is refusing to grant the relief. So it's a negatively worded provision. So it talks about when an enforcement cannot be granted. It doesn't say when it can be granted. So it's a negative way, a reverse way of discussing about enforcement. So what Article 5 says, the first part, the competent authority of the party to the convention where relief is sought under Article 4 may refuse to grant relief. Now, please take a note of these words, may refuse to grant relief. So, may here gives that discretionary power to the court. It's not mandatory. It still gives discretion. It's left to the discretion of the court of a particular country where the enforcement proceedings are being sought for to grant or not to grant. Correct? So this is why it says may refuse to grant relief at the request of the parties against whom the relief is sought. Okay. Only if. Now these are again important words. Only if. So it restricts the grounds on which the relief may not be, or the relief may be refused. So these are exhaustive. So only if, not anything else apart from this. Only if that party furnishes to the competent authority proof. What proof? Number one, a party to the settlement agreement was under some incapacity. Now, here, before I go further, I would suggest that you also read, once you have gone through this, also read the New York Convention side by side to this, because most of these grounds have been taken from New York Convention, which is applicable for arbitration. Yeah. So these are the, and just like New York Convention, where there are very, very limited grounds for refusing enforcement or for challenging the award. Similarly, here also, very limited grounds have been mentioned where the relief can be refused by the court. And that is why I said, again, only if. These two words are very important, which limits the ground, which makes it a very exhaustive list beyond which a court may not go for, a court may not consider any other grounds. Correct? So I would suggest that please also read Article 6, I suppose, if I recollect, of New York Convention. Yeah. So these are the same, almost similar grounds. Okay. So the first ground is that the party was under some incapacity. Incapacity in form of maybe understanding. So this incapacity has to be read or understood with respect to that particular country's law where these reliefs are being sought. Not general, because each country has different laws so far as a party's capacity to contract is concerned. Why we are saying party's capacity? Because ultimately this agreement, we are talking of a settlement agreement, which is nothing but a contract or an understanding between parties. So different countries would have different laws with respect to who can enter into a contract or an agreement. Yeah. So that is why it says the party to settlement agreement who's actually uh, opposing has to prove that that particular party was under an incapacity for signing that settlement agreement. Correct. Second ground, the settlement agreement sought to be relied upon is null and void, inoperative, or incapable of being performed under the law to which the parties have validly subjected it, or failing any indication thereon, under the law deemed applicable by the competent authority of the party to the convention where relief is sought. Now, let me simplify this. You see, in arbitration, or for that matter, in court litigation, we have, and in general, when we go into a contract, there is a clause of governing law of the contract, which defines the rights and liabilities of the parties so far that contract is concerned. And then in case of an arbitration, we have a law of the arbitration as well. But there is no such concept in mediation. So everything goes back to the original contract under which, now here we are assuming that this is a commercial dispute. Okay, so therefore there might be an agreement already executed between parties, and there is a dispute out of that agreement which is now being mediated, and on which basis the parties have come to a settlement agreement. Okay, so we are just assuming this scenario, and then you will be able to understand why when we are discussing about Article 5. So in keeping that assumption in your mind, when we, so what this says that this agreement is null or void or inoperative or invalid on the basis of the law which is agreed by the parties to be the governing law, or on the basis of the law to which the parties have agreed that they will be bound by. You see, in contracts, and especially in international contracts, the governing law is a very important aspect to decide where and which court would finally decide a dispute between the parties. So based on that, it is here that can be another ground, because it may happen that in many jurisdictions there might be a law which prohibits one particular kind of dispute to be settled this way. Yeah, which may say that no, all these kind of dispute will have to be resolved. I mean, they have to be referred to court only. Only court has a jurisdiction. Like, let me give an example of India. I mean, in India, a family law matter, so far as divorce is concerned, cannot be that way, cannot be gone through arbitration mediation. Though people are trying for mediation, but ultimately they have to approve the court to finally put that seal of the court on that particular understanding between the parties. So this is what it's saying. This is what it's saying, that if the parties have agreed upon some particular law to which they say that we are bound by this law, this contract would be governed by this particular law. And if that law of the country prohibits such kind of agreement, then the court may refuse the enforcement of that settlement agreement. Correct? That is one part of it. Then second, this particular settlement agreement is not binding or final according to its terms. Now, to be very honest and frank with you, I really don't understand why this particular provision is being inserted, because as we all know, mediation is not binding process. But when the parties are entering into a settlement agreement, in that settlement agreement, if they are still writing that it's not final and binding, then what is the purpose? So I really don't understand the purpose behind this particular provision, but it is still there. And there might be situations where the party can rely upon or may rely upon this particular provision of law to challenge enforcement of settlement. But I really doubt that the practical aspect of it. All right. And the settlement agreement has been subsequently modified. Now, again, from a practical aspect, I don't know how this situation may arise, because ultimately a person who's seeking enforcement would definitely approach the court with all the facts and documents and what is there on record. Correct? Then why or when there can be a question of not putting before the court or the competent authority that this particular agreement was subsequently modified. Well, these are all situations which uh, require some live cases yet to be judged or yet to be adjudicated by the courts. So far this, because this convention is still fairly new for all the signatory countries, but these are the pro anyway, but we have to understand, we have to consider these grounds which are part of the convention, which is signed by more than 50, initially 46 countries to start with. I think it has reached around 50, I suppose. So these are another grounds where the enforcement can be refused. Then it talks about a situation where it says that the obligations in the settlement agreement have been performed. Well, if that has been performed, then there is no question of approaching the competent authority. It's very obvious. So if the obligation have been performed, there is no issue of enforcement. Very simple, understand. Or are not clear or comprehensible. Now again, what are the degrees to which a court would arrive at this kind of this kind of a conclusion that the terms of the settlement agreement are not clear or comprehensible? Depends upon case to case. There is no standard rule which can be made up. It all differ from case to case. So again, it may happen that just for understanding, it may happen that the agreement terms are vague, yeah, uh, and which from a court perspective may not be clear as to who's going to perform what and when and how. So if these questions, how, when, what, when, why, yeah, are not clearly drafted in the settlement agreement, then this particular ground can be utilized, can be applicable for setting aside or for refusing the enforcement. Then again, another ground, granting relief would be contrary to the terms of the settlement agreement. Again, a very, very widely open ground made, and which made me think that why these kind of open-ended grounds are being made and what purpose we are going to achieve with this. And that's why, again, coming back to my initial remarks of when I said that this particular topic is contradictory. And this is why I'm saying this, that ultimately, when we are talking of a mediated settlement agreement, when it is assumed and validly can we presume that the parties were at a common ground of understanding and with their own full volition, they have signed the settlement agreement, then why there would be such kind of grounds of challenging or refusing enforcement? This should have been put before the mediator himself or herself at that particular time. And as I said, it is not binding on either party, and then the parties who agreed, of who felt aggrieved, would have walked out, and mediation would have come to an end. Matter should have ended there. Why you allowed the whole process to go through? You sat across with the other parties. You discussed on the terms, entered into a settlement, and thereafter you are challenging it. Then the whole purpose of mediation is lost for that. Correct? But there is a flip side of it also, and I'll come to that. But this is what the initial thought would come to your mind, and which came to my mind as well, that why we are talking of enforcement. You see, we are talking of win-win situation, parties at all the parties as consensus, everybody is on the same page. Then why enforcement? But as I said, there is a flip side of it, and I am not concluding, I am not giving a conclusion to this. I will keep this particular subject open for your own thought process based on today's discussion. And of course, on the questions which you may have, the doubts what we discussed today, I'll leave this for your own understanding, for your own thoughts to share with me. What do you feel about it? All right. Okay. So let's move further. Then there is another ground similar to, as I said, the New York Convention, which says that there was a serious breach by the mediator of standards applicable to the mediator or the mediation, without which breach that party would not have entered into a settlement agreement. So here, normally uh, it's very difficult to lay down any standards for the mediators apart from the general which we all know, which is applicable both to the arbitrators as well as mediators. Yeah, because a mediator is, impartial, neutral, third party, without any capacity or power to, give any solution to the parties. That's what. So these are general guidelines, and maybe in case of an institutional mediation, they might be set, guidelines for the mediators as well. But apart from that, there are no such standards through which a person, I mean, which can be laid down to, conclusively say that there is a breach on the part of mediator. Well, impartiality definitely is one of the main important factor which can be used for this particular ground, or neutrality for that matter. Confidentiality is another important aspect of mediation which can be breached by the mediator. Uh, you know, in case during the caucus as such. So these are some of the general, um, we would say, uh, instances where it can be said that the mediator has breached the standard as may be applicable. Now, but again, why those kind of breaches or these instances were not agitated or discussed before the mediator himself or herself? Why, the party allowed the whole process to go through, sign the agreement, and then coming back to the court and saying that the mediator was impartial? So again, to what extent these grounds would be helpful or should be used by the parties, very honestly, I have no clear answer as of now, to be very honest with you. And because, as I said, it is really, I mean, difficult to understand from a party's perspective why a party would allow the whole process to go through and then challenge it. There was no stoppage, unlike in arbitration, where party has to wait till the award to come and then challenge uh, at, under the challenge process as per the institutional model law or respective country's law on arbitration. But here there was no such stoppage. The parties would have moved out, as I said, would have left mediation process. The matter would have ended there. But the fact now is that you are allowing the other party and the mediator to run through the whole process, then challenging it. How far it's purposeful, there's still a question mark. And then there's another ground which says that there was a failure by the mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality or independence. So this is what I discussed about. It's similar to the New York Convention, so where the arbitrators' impartiality and independence is concerned. And so this is again similar grounds as in case of arbitration. And then again, copying from the New York Convention, the second part of this particular article also talks about where the court may refuse to grant relief if granting relief would be contrary to the public policy of the party, or the subject matter of dispute is not capable of settlement by mediation under that law of that party. So again, you see, uh, what transpires from this is that it seems to be a cut copy paste, situation uh, from New York Convention to this convention. Now, it may happen that, or it is always not necessary that what is good for arbitration is as well good for mediation, or what is applicable in case of an arbitration is also applicable in mediation. No, because these two are totally different processes. But still, they are saying about public policy, about, now in arbitration we said arbitrability of a dispute. So here we are talking of mediability of a dispute for that sort of, if I just go with the similarities for that matter. So again, it boils down to the parties' freedom of choosing a process and choosing to resolve a dispute. We say that mediation is where you get the fullest of the party autonomy as compared to arbitration. But then when we read these two grounds of refusing enforcement, it makes us think twice that is it true? Is there really party autonomy? Because if that has been the case, then where is the question of public policy? Where is the question of a dispute not being, allowed to be settled through mediation? Now, so far as the second part is concerned, this is my personal view, all those disputes that can be arbitrated can very well be mediated. There is no doubt about that. If a particular dispute can be arbitrated, it can definitely be mediated. The reverse may not be true as such, because there are restrictions to arbitration, the arbitrability of a dispute. But certainly, the dispute with those can be arbitrated can certainly be mediated. So if that is the case, then again we need to think, why this ground? What are the instances, what are the disputes that cannot be mediated? And immediately the first such dispute which comes into play is, of course, criminal offenses. Definitely, in the criminal offenses, those which have the adverse impact on the life and liberty of a person certainly cannot be mediated, because then a very, very bad precedent would be there in the society, and it will become an excuse or a ground for such criminals to justify their act as such. So definitely, this can be an instance. Then what else? So generally speaking, those criminal or those offenses which hurts a person's body or freedom, for that matter, should not be mediated, because a particular deterrent has to be laid down in the society. But apart from that, in all commercial matters, for that, why a dispute cannot be mediated? Why? I think it should be. But again, different jurisdictions have different laws in their particular, uh, you know, country which imposes, sort of a mandate which on the dispute that can be mediated or the dispute that can be arbitrated. Now, so far as mediation is concerned, I don't think there are any such so-called laws in any such jurisdictions who have signed this convention which prohibits dispute to be mediated. Uh, if I talk of India for that matter, we are just about to come out with a mediation law, which is again based similarly on the New York Convention and the model law on arbitration. And there, of course, there are some you see a restriction being placed on what matters can be mediated. But otherwise, I'm saying, generally speaking, I don't think there should be an issue of any mediation or any dispute to be initially mediated before it goes to whether to the court or to arbitration or whatever other dispute resolution forum. So to that extent, I don't uh, think that this particular ground is that useful for that matter. In fact, it would actually restricts the flexibility of the whole process of mediation. Now, coming to the flip side, as I was talking about, of why we are talking of enforcement. You see, what happens that though we say that this is a win-win situation, the parties have agreed through their own discussion, through their own efforts, of course, with the facilitation of the mediator, to arrive at a particular way of resolving their dispute. But in the end, what what they get is what we say is a settlement agreement. Now, so in nutshell, it's still an agreement in the sense that that particular agreement would say who will perform what or who will do what or who will not do what. Correct? This is what a general settlement agreement would have the contents so far. I mean, in general. So therefore, as since it is still an agreement at the end of it to be performed, yeah. What if a party does not perform? What is the recourse to the other party in such a case? Because this is a simple agreement. Though they would have said that this finally resolves our dispute, but then you see again on that particular settlement agreement itself there will be a dispute. There can be a dispute, like these grounds for that matter. So does the agreed party in this case, in such a scenario, is without any recourse or should be left without any recourse? Of course not. Then what is the remedy? And remedy is this. That is why this Article 5 has been inserted to ensure that ultimately, if such kind of, if one party plays malafide, then the agreed party is secured, his rights are secured in the way that court or the competent authority would in that case enforce the settlement agreement, and then it become a verdict of the court. Yeah. So this is the flip side why we are talking of enforcement. But yes, as I said, on the initial thought, it definitely seems contradictory. It definitely, make you think that then what is the purpose of mediation? If we are still, in the again going back to the same loophole of the court process of challenge and enforcement, then what is the difference between mediation and arbitration? Then the parties might as well, uh, refer the dispute to arbitration rather than mediation. Because even after mediation, you have to still approach the court. There is still one layer of that particular forum to get this settlement agreement authenticated, yeah, or binding upon the parties. Then why you waste that particular time? You should straight away approach the court or the arbitration for that matter. But as I said, mediation definitely has its usefulness. It has been seen, and there are surveys to that effect, and even through my own experience, I can say that many a times the disputes those are being referred to court or to arbitration have been resolved with the help of mediation, more quickly, more efficiently, and in much cheaper way. That's the you see importance or benefit of mediation. So definitely, uh, mediation is the future, and I would suggest, and I would in fact, advise all of you who wants to pursue your career, maybe in law or maybe in even consultancy, or for that matter, even in your general day-to-day life, mediation is the key for a peaceful living. Yeah. Thank you so much.
Thank you, sir. Now we will take some questions from our lovely audience. Participants can ask their questions in the chat box. So, in case of ISDS, if the issue is resolved through mediation, can the settlement agreement using the Singapore Convention, in other words, whether ISDS disputes are commercial disputes?
Well, of course, ISDS disputes are not commercial disputes, but the convention is definitely applicable there as well, and that is one of the reason why the convention does not specify so far as commercial or investor state disputes are concerned. All right. So ISDS are definitely not commercial, though they have a part of it, of course, is commercial, but they they are on a different general altogether, because the parties are on a different footing altogether.
Thank you, sir. Thank you so much for such a vibrant, interactive, and knowledgeable session. I would also like to thank all the participants for joining us, and I request everyone to fill up the feedback form and before you leave and to receive your certificates. Thank you so much for joining us. Mediate Guru
And
is
I give you this liberty to share my email to the with the participants. Those who want to discuss about it, share their thoughts, and discuss further into this are free to do that. Connect with me on LinkedIn. You can send me an email from them, and then we can take it forward from there. All right. Thank you so much.
thank you, sir.